50 The Law of Divorce 1. Applicability in 2003. The Court of Appeal for Ontario held that the common law definition of marriage as a voluntary union of one man and one woman violated S15 of the Canadian Charter of Rights and Freedoms, Charter, and was not saved under S1. Halpern v. Toronto City. In June 2003, the Government of Canada announced it would not appeal the decision of the Court of Appeal and those of courts in 7 other jurisdictions in Canada that had ruled similarly on the definition of marriage. Instead, a proposal extending civil marriage access to same-sex couples would be drafted and sent as a reference to the Supreme Court of Canada. In December 2004, the court ruled that the proposal to define marriage as a lawful union of two persons to the exclusion of all others was within the exclusive legislative authority of the Parliament of Canada, while the proposal to allow religious groups to abstain from marrying same-sex couples was not. It further recognized that S91, 26, of the Constitution Act, 1867 confers exclusive authority on Parliament to legislate in respect of the capacity to marry, whereas S92, 12, confers authority on the provinces in respect of the performance or solemnization of marriage once that capacity has been recognized. It ruled that the government's proposal to extend the ability to marry to same-sex couples was consistent with the Charter and that the freedom of religion, guaranteed by S2, protects religious officials from being compelled to perform a marriage between two persons of the same sex that is contrary to their religious beliefs. Finally, the court declined to exercise its discretion to answer the question of whether the opposite sex requirement for marriage, as established by the common law and set out for Quebec in S5 of the Federal Law, Civil Law Harmonization Act, No. 1 was consistent with the Charter. In the case of M.B.H.J., Justice Ruth Mesper of the Ontario Superior Court of Justice ruled that the heterosexual definition of spouse in the Divorce Act DA was unconstitutional, having infringed the equality guarantee in S15, 1, of the Charter and could not be saved pursuant to S1. The court ruled that the appropriate and simplest remedy was to redefine the word spouse to mean two persons who are married to each other and to read in that definition into the DA. Civil Marriage Act. The Civil Marriage Act came into effect with royal assent on July 20, 2005. The Act extends the legal capacity for marriage for civil purposes to same-sex couples in order to reflect the values of tolerance, respect, and equality consistent with the Charter. It also makes consequential amendments to other acts to ensure equal access for same-sex couples to the civil effects of marriage and divorce. Specifically, S2 of the Civil Marriage Act confirms that marriage, for civil purposes, is the lawful union of two persons to the exclusion of all others. In order to safeguard the guarantee of freedom of conscience and religion, it is recognized that officials of religious groups are free to refuse to perform marriages that are not in accordance with their religious beliefs. S3. No person or organization can be sanctioned or deprived of any benefit for believing or expressing the belief that marriage is the union of a man and woman to the exclusion of all others. S3.1. The most obvious consequential amendment to family law legislation is that the opposite-sex definition of spouse in the DA is replaced with a gender-neutral reference to two persons who are married to each other. DA. S8.1. 2. Types of proceedings. There are 3 different types of proceedings under the DA: divorce proceedings, corollary relief proceedings, and variation proceedings. A divorce proceeding is one in which either or both spouses seek a divorce alone or together with a child support order, spousal support order, or custody order. Practitioners should be aware that as a result of changes to the DA that come into effect on July 1, 2020, the words custody and access will be struck from all federal legislation insofar as they relate to children, to be replaced by decision-making responsibility and parenting time. A new kind of order, called a parenting order, can include an order related to decision-making responsibility and/or parenting time. A corollary relief proceeding is one in which either or both former spouses seek a child support order, spousal support order, or a custody parenting. As of July 1, 2020. Order. This allows the parties to divorce at an earlier stage and deal with corollary issues at a later date. A variation proceeding is one in which either or both former spouses seek a variation order. S2. 1. A variation order varies, rescinds, or suspends, prospectively or retroactively, a support order or a custody order. Parenting order as of July 1, 2020 or any provision thereof. S17. 1. Other claims may be made in a proceeding for divorce whether they derive from the federal statute as claims for support or custody. from provincial legislation as claims with respect to property and division of property, or from the common law for any other relief. 3. Jurisdiction. A court in a province has jurisdiction to hear and determine a divorce proceeding if either spouse has been ordinarily resident in the province for at least 1 year immediately preceding the commencement of the proceeding. 3. 1. A court in a province has jurisdiction to hear and determine a corollary relief proceeding if either former spouse is ordinarily resident in the province at the commencement of the proceeding or both former spouses accept the jurisdiction of the court. 4. 1. A court in a province has jurisdiction to hear and determine a variation proceeding if either former spouse is ordinarily resident in the province at the commencement of the proceeding or both former spouses accept the jurisdiction of the court. 5. 1. 2 proceedings commenced where divorce proceedings between the same spouses are pending in 2 different courts and started on different days and the first proceeding is not discontinued within 30 days. The proceeding commenced first has exclusive jurisdiction to hear it. 3. 2. This is similarly true of 2 corollary relief proceedings or 2 variation proceedings between the same former spouses that are pending in 2 courts and were commenced on different days. 4. 2. And 5. 2. The requirement that the first proceeding be discontinued within 30 days after being commenced will be, as of July 1, 2020, no longer in effect. The new rule will be a welcome change since, in many cases, the second proceeding is started long after the 30-day period has passed and is the better one to proceed with, because, for example, it has the most current information. The amendment will provide the parties more time to discover the duplication of proceedings and to determine which proceedings should be discontinued. When proceedings are started on the same day in different provinces, the federal court has jurisdiction over the entire proceeding, unless one of the proceedings is discontinued within 30 days of being commenced. A new change, in effect on July 1, 2020, will limit the federal court's authority to jurisdiction only and extends the time to discontinue one of the proceedings from 30 to 40 days. 3, 4, 3, and 5. 3. The court's ability to transfer a divorce, corollary relief, or variation proceeding involving a custody order will also change on July 1, 2020. If the child in question is habitually resident in another province, the court may, on application or its own motion, transfer the proceeding to a court in that other province. 6. 1. 2. The change from substantially connected to habitually resident makes the DA more consistent with provincial and territorial statutes and international law. It also accommodates other changes to the DA related to parenting. The new provision will eliminate the phrase "and is opposed," which limits the court's ability to effect a transfer only in a case where the relief claimed was opposed. Contact orders, child abduction, children habitually resident outside Canada. New provisions will also be created on July 1, 2020, regarding a contact order, a new term to apply to a parenting order sought by a non-parent, child abduction, and children habitually resident outside Canada, provided no variation proceeding is pending. A court in a province where the child is habitually resident will have jurisdiction to hear and determine a contact order. However, the court will have the power to decide that a court in another province is better placed to hear and determine the case. 6.1. 2. The new legislation confirms that an application for a contact order may be brought to the court only when considering a parenting application, and then, only with leave of the court. 6.1. 3. And 16.5. 3. The new 6.2. 1. Will provide that if a child of the marriage is unlawfully removed from or unlawfully retained in a province, the court in the province in which the child was habitually resident that would have had jurisdiction before the unlawful removal or retention has jurisdiction to hear the case unless the court is satisfied that all persons who are entitled to object to the removal or retention have ultimately consented or acquiesced to the removal or retention. B. There has been undue delay in contesting the removal or retention. Or C. A court in the province in which the child is present is better placed to hear and determine the application. The new provision aims to help prevent parental child abduction and to encourage compliance with the notice requirements set out in the DA and provincial legislation. Subsection 6.3. 1. Will provide that if a child of the marriage is not habitually resident in Canada, a court in a province that would otherwise have jurisdiction to make a parenting, contact, or variation order has jurisdiction to do so only in exceptional circumstances and if the child is present in the province in determining whether there are exceptional circumstances. The court must consider all relevant factors, including whether there is a sufficient connection between the child and the province, the urgency of the situation, the importance of avoiding multiple proceedings and inconsistent decisions, and the importance of discouraging child abduction. 6.3. 2. Spouses and former spouses. The interplay between the status of the parties as spouses or former spouses important. The Court of Appeal for Ontario has confirmed the following: Okmiansky v. Okmiansky. An Ontario court does not have jurisdiction to hear and determine a corollary relief proceeding under the DA following a valid divorce in a foreign jurisdiction. An Ontario court does not have jurisdiction under the Family Law Act (FLA) to hear and determine a support claim made by a former spouse. An Ontario court does have jurisdiction under the FLA to hear and determine an equalization claim following a valid divorce in a foreign jurisdiction. 4. Duties on parties effective July 1, 2020. The DA will impose several new duties on the parties. Any person who has parenting time, decision-making responsibility, or a contact order must exercise that time, responsibility, or contact in a manner that is consistent with the best interests of the child and shall, to the best of the person's ability, protect any child from conflict arising from the proceeding. SS 7.1 to 7.2. These amendments to the DA remind parties of their obligations. A more significant change is S 7.3, which, for the first time, will mandate parties to a proceeding to try to resolve the matters in dispute through a family dispute resolution process to the extent that it is appropriate to do so, where there has been family violence in the past or the threat of family violence exists, or where there is a significant power imbalance. It may not be appropriate to require the parties to mediate or try other forms of dispute resolution. In some cases, court is the better option. It will be interesting to see how this new section will be interpreted by the courts. New S 7.4 will require a party to a proceeding under the DA to provide complete, accurate and up-to-date information if required to do so under the Act. Finally, new S 7.5 will require a person subject to an order to comply with it until it is no longer in effect. This clarifies that even temporary orders are valid until vacated or subject to a final order. 5. Breakdown of marriage. The only ground for divorce in Canada is breakdown of the marriage. S8. 1. A breakdown of the marriage can only be established once the spouses have lived separate and apart for at least 1 year immediately before the divorce proceeding is determined and are still living separate and apart at the commencement of the proceeding, or the spouse against whom the divorce proceeding is brought has, since the marriage was celebrated, committed adultery or treated the other spouse with such physical or mental cruelty as to render intolerable the continued cohabitation of the spouses. S8. 2. In an application for divorce where adultery is pleaded, the other person with whom the spouse committed adultery does not need to be named. If named, however, that person must be served with the application and has all the rights of a respondent in the case. Family law rules. Rules. R36. 3. Where a couple reconciles for 90 days or more and then separates again, the date of separation is the second date. Another way of stating this is that a period during which spouses have lived separate and apart shall not be considered to have been interrupted or terminated because the spouses resumed cohabitation during a period of or periods totaling not more than 90 days with reconciliation as its primary purpose. DA. S8. 3. B. 2. Whether this has occurred is a question of fact. 6. Bars to divorce. The DA contains 3 obstacles or bars to divorce. First, if the court finds there has been collusion, the court must dismiss the application. Collusion is defined as an agreement or conspiracy to which an applicant is either directly or indirectly a party for the purpose of subverting the administration of justice and includes any agreement, understanding, or arrangement to fabricate or suppress evidence or to deceive the court. S11. 4. Courts have interpreted collusion in divorce applications to include the dissolution of marriages that are part of an immigration scheme. The DA is clear, however, that collusion does not include an agreement to the extent that it provides for separation between the parties, financial support, division of property, or custody of any child. S11. 4. Effective July 1, 2020. This provision will replace the words custody of any child of the marriage with the exercise of parenting time or decision-making responsibility. Second, if the court finds that reasonable arrangements for the support of the children have not been made, the granting of the divorce must be stayed until such arrangements have been made. S11. B. Ideally, these arrangements are reduced to writing in a court order or separation agreement. The absence of any written arrangement or any support arrangement at all does not necessarily preclude the divorce from being granted. One of the most common hurdles in obtaining a divorce is when the parties seek to include in a court order terms for child support that differ from those that would apply under the Federal Child Support Guidelines. That is because S15.1.3 of the DA provides that a court making an order shall do so in accordance with the applicable guidelines. Accordingly, where married parties seek a child support term in a court order that differs from that under the guidelines, details must be supplied in an affidavit sufficient to persuade the court that reasonable arrangements have been made for the support of the children. S15.1.8. The parties' arrangement will not be considered unreasonable solely because it differs from the guidelines. S15.1.7. Third, where the divorce is proceeding on a breakdown of the marriage based on adultery and the applicant has condoned or connived in the act or conduct complained of, the application must be dismissed unless in the opinion of the court the public interest would be better served by granting the divorce. S11.1. Although there is no definition of connivance in the DA, case law has defined it as the corrupt intention by a spouse of promoting or encouraging either the initiation or the continuance of the adultery of the other spouse. 7. Lawyers' duties at present. The DA requires every barrister, solicitor, lawyer or advocate to draw to the spouse's attention the provisions of the DA that have as their object the reconciliation of spouses and discuss with the spouses the possibility of reconciliation before the application is signed, including the availability of marriage counseling or guidance facilities that might be able to assist the spouses in achieving reconciliation. The lawyer or advocate does not have to comply with this section where the circumstances of the case are of such a nature that it would clearly not be appropriate to do so. S9.1. The lawyer or advocate must also discuss with the spouse the advisability of negotiating matters that may be the subject of a support or custody order and to inform the spouse of the mediation facilities known to the lawyer that might be able to assist the spouses in negotiating these matters. S9.2. Effective July 1, 2020, S9 is repealed and reenacted as S7.7. In S7.7, the words barrister, solicitor, lawyer or advocate will be replaced by every legal advisor. The term legal advisor will be defined in S2.1 as any person qualified in accordance with the law of a province to represent another before the courts in a province. Subsection 9.2 will be amended to reflect the legal advisor's obligation to inform the person of the party's duties under the DA and of any family justice services that might assist in resolving the matters in dispute and complying with any order or decision. S7.7.2.8. Courts' duties. Families sometimes become involved with various parts of the justice system at the same time. A separation may trigger not just a claim in family court but a criminal charge. Bail restrictions against a parent may impact on parenting provisions either sought in court or already in place by a family court judge. To improve the system, new provisions coming into effect on July 1, 2020, aim to facilitate the identification of orders, undertakings, recognizances, agreements, or measures that may conflict with an order under the DA and to facilitate coordination of proceedings. SS 7.8.1, 2, 9. Splitting of divorce. The rules allow for the splitting, or severing, of the divorce claim from all other claims in the case if neither spouse will be disadvantaged by the order and reasonable arrangements have been made for the support of the children. Rules. R12.6. DA. S11.1. B. A spouse may be disadvantaged if that spouse's entitlement to health benefits under an employment benefit plan ceases, which typically occurs once the parties are no longer spouses. Furthermore, since the granting of an order for exclusive possession can only be made in favor of a spouse, the granting of a divorce order